How would you feel about the possibility of compulsory retesting for those that are found to be not competent to drive? That is a recommendation being put forward by several MPs of the all-party parliamentary group for cycling and walking. But retesting is not a new thing. It's already available in law for those that are convicted of dangerous driving and several other serious offences. But the problem here is lots of people are re-offending. Now, many of you watching may never have been convicted of anything so much as a speeding ticket, but many people are re-offending and committing the same offences again and again. And the recommendation is, potentially, that those that are repeat offenders should have escalating penalties and potentially even a compulsory retest if they are found to be incompetent at driving. Statistics show that 47% of those that are convicted for driving whilst disqualified have at least one conviction of that offence beforehand, and 30% have had 2 or more convictions for the same offence. So there's an arguable case for escalating penalties for those that are found to be repeatedly violating the law and committing these offences. Now, whilst most people, if not everybody, would probably not like the idea of retaking their driving test, compulsory retesting has been found and established as an effective way of keeping the worst of the drivers off the roads. Now, whilst many people do still drive whilst disqualified, the compulsory retest is certainly one way to protect other road users from those worst of the drivers. But as I said, many offenders are repeat offenders, so one of the suggestions is to escalate the penalties for those offenders, not just to include bans, but also potentially vehicle confiscation, fines, community service, and even custodial sentences. Another recommendation is that exceptional hardship, which I'll explain in a moment, should be truly exceptional. Because of those that rely on the mitigation of exceptional hardship, 23% who have reached 12 penalty points successfully argue against a disqualification on the grounds of exceptional hardship, which usually should mean that it is really exceptional, as in somebody else would suffer as a result of you being banned from driving, and by default they are innocent, and so if you can show that they will suffer hardship, you might escape a ban. Now, one of the ways this frequently comes about is totting up to 12 points, colloquially referred to as a totting ban. When you accrue 12 penalty points on your driving licence, the court is obliged to disqualify you from driving for a minimum period of 6 months, unless you can show exceptional hardship. But with 23% of those making that argument being successful and escaping a driving disqualification, this latest guidance is suggesting that this is radically reformed so that exceptional hardship should be truly exceptional, which would significantly reduce the number of those who successfully rely on this mitigation. Now, many people will be familiar with the phrase that you probably wouldn't pass your driving test if you were to retake it today. But that's quite a problem, because today's standards are obviously very different than they were 20 or 30 years ago. But that doesn't mean that it should be okay to drive to a lower standard just because you took the test many years ago. But if it really is the case that you wouldn't pass a test by today's standards, perhaps it stands to reason that you should be brushing up on some of those skills and brought back up to today's standards for the safety of yourself, your family, and of course everybody else on the road. Another recommendation in the parliamentary group report talks about speed, as in the removal of the tolerances to speed enforcement of offences. Now, public opinion polls suggest that 82% of people believe that it's not safe to speed, whereas 8% who think exactly the opposite. So 8% of people believe that it's perfectly safe to speed, whereas excess speed is obviously a significant contributory factor to many road collisions. Now, as I've said in videos before, many people believe that there's a provision in legislation for a tolerance to the speed limit. Many people refer to this as 10% plus 2, or different figures for different areas. There is no such legislative tolerance. It is simply different police forces applying their own tolerance and guidance and a degree of discretion depending on where you are in the country. There are some useful tables that show what these tolerances are. If I find it, I'll put it on screen now, otherwise I'll link it below. But this guidance, as I said, suggests that this tolerance should be completely removed. After all, the speed limits should be there for a reason, and people should comply with those speed limits. And finally, just one of the many case studies that's discussed in this report is that for the use of a mobile phone. You know that I've been vocal on this channel against the use of mobile phones, and there's a lot of debate over this over on X, Twitter. One of these case studies said that Christopher Gard appeared before magistrates in 2015 because he'd amassed 12 points on his driving licence for the use of a mobile phone whilst driving. This was his 8th conviction for this offence and had twice avoided the conviction previously by attending driver's awareness courses. However, using the mitigation of exceptional hardship to say that he was self-employed and his family would suffer if he couldn't drive, magistrates allowed him to keep his licence on exceptional hardship grounds. He promised to lock his phone in the boot whilst driving thereafter, but just 6 weeks later he was texting whilst driving once again. He drove into the back of a cyclist who was then thrown onto the front windscreen and killed. He tried to cover up his mobile phone use by deleting the text messages, and then he was jailed for 9 years at Winchester Crown Court for causing death by dangerous driving, and of course banned from driving, this time for 14.5 years. He appealed to have this sentence reduced, but that appeal was dismissed in 2017. So I hope you'll agree that this case study shows the very severity of what these offences can actually go on to cause. So there's some very real and very good reasoning behind the recommendations in this report, which I'll link in the description below. As always, let me know your thoughts and comments in the comment section below. Let me know your attitudes towards speeding and texting while driving. Some people think it's perfectly innocent, but as the case studies show, it is certainly not a victimless crime. Thank you for watching. Make sure you like and subscribe. I'll see you next time.